You know what's strange? A $500 piece of paper can sometimes do more for a family than a $500,000 house. That sounds backwards, doesn't it? But stay with me for a second, because I want you to imagine two neighbours. Two houses, side by side, same street, same value, same kind of family. One of them dies without a will. The other dies with a simple, properly done will that probably cost around $500 to put together. Same town, same state, same courthouse. And yet, 18 months later, one family has settled everything, kept almost every dollar, and moved on with their lives. The other family is still in court. They've spent tens of thousands of dollars on legal fees. They've had arguments over who gets what, and somebody who never even talked to their dad in the last 10 years is now legally entitled to a chunk of the estate, just because of how state law fills in the blanks when there's no will. That's not a guess. That's how the math actually works when an estate goes through a contested or even just a messy, unplanned probate process. So today, I want to walk you through a story. It's not about one specific real family. It's an illustrative example, the kind of situation that plays out in courthouses across the country every single week. But it shows you, step by step, exactly how a $500 will ended up saving a family something like $50,000. And by the end, you're going to understand exactly why this happens and what you can do to make sure it doesn't happen to the people you love. Before we go any further, let's just get something out of the way, because I think it matters and I want to be straight with you about it. I'm not an attorney, I'm not a financial advisor, I don't have a law degree, and I'm not going to pretend I do. What I am is someone who spends a lot of time researching how estate planning actually works in the real world, breaking it down so it's plain English instead of legal language, and sharing it with you so you can have better conversations with the professionals in your life. Everything you hear in this video is general education, it's not legal advice, and it's not a substitute for sitting down with a licensed estate planning attorney in your own state. Because here's the thing, estate law is not one size fits all across this country. The rules about probate, about intestacy, about what a will needs to be valid, they vary from state to state, sometimes in ways that surprise people. So think of this video as the foundation. It's the "here's how this generally works and here's why it matters" conversation. The specifics for your situation, that's a conversation for you and a licensed attorney where you live. Now, why does this matter right now, today, for you? Because probate isn't some rare, unusual thing that only happens to other people. It happens to almost every family eventually, in one form or another. And when there's no will, or when the will is poorly done, the costs aren't just financial, they're emotional too. Families that were close can end up bitter, siblings can stop speaking, and often the people footing the bill for all of this confusion are the very people the deceased loved most and wanted to protect. So this isn't really a video about paperwork. It's a video about protecting your family from a problem most people don't even know exists until they're standing right in the middle of it. Here's what I want you to walk away with by the end of this video. You're going to understand what happens, legally and financially, when someone dies without a will, what's called dying intestate. You're going to understand exactly where the costs come from when an estate drags through probate, and why those costs can balloon so much faster than people expect. And you're going to see, through our illustrative family story, the specific moments where a simple will changed the entire outcome. If any of this is useful to you, and I think it will be, go ahead and subscribe, because we cover one new piece of this puzzle every single week, from wills and trusts to probate to Social Security and Medicaid planning. Now let's get into it. Let's start with the foundation, because you can't understand why a will saves money until you understand what happens when there isn't one. When a person dies without a valid will, the law doesn't just leave things up in the air. Every state has what's called an intestacy statute, a built-in, default set of rules that decides who inherits what. It sounds organized, and in a way it is, but here's the catch, it's generic. It was written by a state legislature to apply to millions of different families with completely different situations, and it has no idea who you actually wanted to leave things to. It doesn't know that you wanted your daughter to have the house because she's the one who's been taking care of you. It doesn't know you wanted to leave something to a stepchild you raised since they were 2 years old, but never legally adopted. It doesn't know about the friend who became more like family than your actual family. Intestacy law only sees blood relationships and legal relationships in a strict hierarchy, usually starting with a spouse, then children, then parents, then siblings, and working outward from there. Here's where it gets complicated, and this is something a lot of people don't realize until it's too late. Many states split an estate between a surviving spouse and children in ways people don't expect. In a lot of states, if you're married and you have kids, your spouse does not automatically inherit everything. Depending on the state, the spouse might get a portion, and the children split the rest. If you have children from a previous relationship, this can get especially messy, because suddenly your current spouse might be legally required to share the estate with children who aren't theirs, sometimes in proportions nobody anticipated and nobody wanted. Without a will, there's no way to express, "No, actually, I want my spouse to have the house outright," or "I want my kids treated equally regardless of which marriage they came from." The state's default rules just run their course. Then there's the matter of who actually administers the estate. When there's a will, you name an executor, the person you trust to carry out your wishes, pay off debts, handle the paperwork, and distribute what's left. That's a deliberate choice. You pick someone responsible, someone you trust, maybe your oldest child, maybe a sibling, maybe a close friend. But when there's no will, there's no executor named, so the court has to appoint what's called an administrator. And this is where families start running into real conflict, because more than one person can petition to be the administrator. Imagine 2 adult children who don't get along particularly well, and now they're both filing paperwork with the probate court saying, "I should be the one in charge of Mum's estate." That alone can trigger a legal dispute before a single asset has even been distributed. Attorneys get hired, hearings get scheduled, and every hour of that process costs money that comes directly out of the estate, which means less for everyone, including the very people fighting over it. This is also where probate court costs start to multiply, because here's something people don't always understand about probate. It's not free, and it's not always quick. Probate is the court-supervised process of validating a will if there is one, identifying and valuing the deceased's assets, paying off debts and taxes, and then distributing what remains to the rightful heirs. Even in a straightforward case, this can take several months. In a contested case, with multiple parties, disagreements over asset values, or disputes over who's entitled to what, it can take years. And every step of that, every filing fee, every court appearance, every hour your attorney spends drafting documents or showing up to a hearing, adds to what's called administrative costs of the estate. Attorneys, depending on your state, can sometimes be paid a percentage of the estate's value, or by the hour, and either way, a longer, more contested process means a bigger bill. That bill gets paid before anyone gets their inheritance. So the estate itself shrinks before it's even divided. Now, let's bring this to life, because numbers and legal terms only mean so much until you see how it plays out for real people. And again, I want to be clear, this is an illustrative example, a composite of the kind of situations that happen across the country, not a specific real family. Imagine a man, we'll call him the father in this story, who owned his home outright, had some savings, a retirement account, and was a widower with 3 adult children. He always meant to get a will done. He talked about it at Thanksgiving more than once, but life got busy, and then one day, unexpectedly, he passed away from a sudden heart issue. No will, no named executor, just 3 grown children, a house worth around $300,000, and roughly $200,000 in combined savings and retirement accounts. On paper, that's a $500,000 estate split 3 ways. Should be straightforward, right? Except 2 of the 3 siblings did not get along. One felt she had done more of the caregiving in her father's final years, and believed she deserved a larger share, even though intestacy law doesn't account for that kind of informal arrangement at all. It only counts equal shares among children, unless a will says otherwise. The other sibling disagreed loudly. The third sibling just wanted it to be over and tried to mediate without much success. Because there was no will, no one had legal authority to act until the court appointed someone, and because two siblings both wanted that role, the appointment itself became contested. That meant attorneys, on both sides. That meant the house, which the caregiving daughter actually wanted to keep and live in, had to be appraised, and because the siblings couldn't agree, it eventually had to be listed and sold so the proceeds could be split, even though that wasn't what anyone originally wanted. The legal fees from the contested administration, the appraisal costs, the court filing fees, the time the estate sat open while documents went back and forth. By the time everything was finally settled, almost 18 months later, the family had spent somewhere in the neighborhood of $50,000 in combined legal and administrative costs. $50,000 that didn't go to any of the three children. It went to attorneys, to court costs, to appraisers, to the slow grinding machinery of an estate that had no instructions. And beyond the money, the real cost was the relationship between two siblings who, years later, still don't really speak. Now picture the version of this story where a few years earlier, that same father had sat down, spent maybe $500 with an attorney, and had a simple, properly executed will drawn up. In that will, he names his caregiving daughter as executor because he trusts her and she's the one who's been most involved. He specifically states that the house should go to her, perhaps with an arrangement to compensate her siblings from the savings and retirement accounts to keep things fair. He puts his wishes in writing, clearly, in a document that meets his state's legal requirements for validity, properly signed, properly witnessed. When he passes away, there's no question about who's in charge. There's no contest over the appointment. The will gets submitted to probate, which still has to happen, but it's a far more streamlined process because everyone already knows exactly what was intended. The court confirms the will is valid, the named executor gets authority to act, the house goes to the daughter as specified, the other assets get distributed according to his wishes, and the entire thing wraps up in a matter of months rather than years, with a small fraction of the legal costs. That $500 will didn't just save $50,000, it saved a family from years of bitterness over something that could have been settled by one clear, signed piece of paper. Let's talk about why this gap is so large, because it's not just about saving on attorney's fees, it goes deeper than that. The first big driver is time. Courts move at the speed of paperwork and hearings, and every additional dispute adds another round of filings, responses, and scheduled court dates. Time is money in probate, almost literally, because many attorneys bill by the hour, and even flat fee arrangements tend to balloon when a case becomes contested. The second driver is appraisal and liquidation costs. When heirs can't agree on who keeps what, assets often have to be formally appraised and sometimes sold, even if nobody really wanted to sell them, just so the value can be divided. Appraisals cost money. Real estate transactions involve closing costs, agent commissions, and sometimes costly delays if the property needs work before it can be sold. The third driver is what's sometimes called the everybody lawyers up effect. Once one heir hires an attorney to protect their interests, others often feel they need to do the same, and now you've got multiple legal bills running simultaneously, often duplicating work, all paid for out of an estate that's shrinking the entire time this is happening. Let's also talk about a piece of this that surprises people. A will does not actually let you skip probate entirely in most cases. I want to be really clear and honest with you about that, because I don't want you walking away from this video thinking a will is some kind of probate avoidance trick. It's not. In most states, having a will means your estate still generally goes through probate, the court process I described earlier, but it goes through it with clear instructions, a named executor, and far less room for dispute. If complete probate avoidance is your specific goal, that's a different conversation. often involving tools like a revocable living trust, beneficiary designations, or jointly held property with rights of survivorship, and we've covered some of those tools in other videos on this channel. But the lesson from today's story isn't a will avoids probate. It's a will makes probate dramatically cheaper, faster, and less contentious, because it removes the biggest cost driver of all, which is family disagreement and legal uncertainty. Now let's go through some of the most common mistakes and myths I see, because I think this is where a lot of families accidentally set themselves up for exactly the kind of situation we just walked through. The first myth is, I don't have enough money to need a will. People think wills are for the wealthy, for people with complicated estates and business interests. But as we just saw, a modest estate, a paid-off house, and some savings is exactly the kind of estate that can get torn apart by family disagreement because there's something real at stake and no instructions for how to divide it. The second myth is, my family gets along, so we won't need a will. I hear this constantly, and I understand the instinct. But grief changes people. Money changes people. The stress of loss combined with the stress of financial uncertainty can bring out conflict in families that otherwise get along just fine. A will isn't an insurance policy against the possibility your family might fight. It's a tool that removes most of the reasons they'd have to fight in the first place. The third myth is thinking that verbal promises count for something legally. Dad told me the house was supposed to be mine. In the eyes of a probate court in most states, a verbal promise generally carries no legal weight at all when there's no written, validly executed will. It might be entirely true, it might be exactly what your father wanted, but if it's not written down properly, the court can't act on it. The fourth mistake is using a generic online template without understanding your state's specific signing and witnessing requirements. Every state has its own rules about how many witnesses are required, whether a notary is needed, and what makes a will valid versus what can get it thrown out or contested. A poorly executed will can sometimes cause more problems than no will at all, because now you've got a document that looks official but might not hold up, and that itself becomes a source of legal dispute. The fifth mistake is doing a will once and never updating it. Life changes, marriages, divorces, new grandchildren, the sale of a home, a falling out with a family member. A will written 15 years ago might not reflect your life today at all, and an outdated will can create just as much confusion as no will. So what should you actually do with all of this? Let's walk through some practical action steps, because I don't want to leave you with just a story and a warning. I want to leave you with a direction. Start by having an honest conversation with yourself about what you actually own. Your home, your savings, your retirement accounts, any life insurance, any personal property that matters to you or to your family. You don't need a complete legal inventory today, just a general sense of what's involved. Next, think about who you'd want to handle things if you weren't here to handle them yourself, your executor. This should be someone organized, trustworthy, and ideally someone who's willing to take on the responsibility, because it is real work. Have a conversation with that person before you name them, so it's not a surprise. After that, think honestly about how you'd want things divided. This doesn't have to be equal in dollar terms to be fair. Fairness and equality aren't always the same thing, and you're allowed to explain your reasoning in conversations with your family, even if the will itself is the formal legal document. Then, the most important step, contact a licensed estate planning attorney in your state. I know it can feel like a hassle, like something to put off, the same way that Father in our story put it off. But the cost of doing it now is almost always a fraction of the cost of leaving it undone, both financially and emotionally for the people you love. Once you have a will in place, don't file it away and forget about it forever. Revisit it every few years, or after any major life change, just to make sure it still reflects your wishes. And finally, talk to your family, not necessarily about every detail, but enough that nobody is blindsided later. The families that handle this best are usually the ones where the parents were willing to have one slightly uncomfortable conversation, while they were still here, instead of leaving their children to guess after they were gone. I think about that illustrative story a lot. The father who meant to get it done, who talked about it every Thanksgiving, and the version of his family that spent 18 months and $50,000 finding out the hard way what happens when good intentions never become a signed document. And then I think about the other version, the one where he just did it, spent an afternoon with an attorney, signed a simple will, and in doing so, handed his children something far more valuable than money. He handed them clarity. He handed them an ending that didn't have to involve a courtroom. Because that's really what this is about, isn't it? It's not about legal documents for their own sake. It's about making sure that the people you love most don't have to navigate one of the hardest moments of their lives while also fighting each other, and fighting a slow, expensive legal process, simply because there was no instruction left behind. A will, done properly, done with a licensed professional who understands your state's laws, is one of the most loving things you can leave behind for your family, even though nobody ever wants to talk about it at the dinner table. So if there's one thing I hope you take from this video, it's this. The cost of doing this now is almost always smaller than the cost of not doing it later, in dollars, and in family relationships that you can't ever fully repair once they've been damaged by a long, bitter probate fight. If this video helped you understand something you didn't know before, please subscribe, because every week we break down another piece of estate planning, probate, and protecting what you've built, in plain English, without the legal jargon. And before you make any decisions about your own situation, please remember that everything in this video is general education, not legal advice. Estate laws vary significantly from state to state, including the rules around wills, witnessing requirements, and probate procedures. So before you make any decisions for your own family, talk to a licensed estate planning attorney where you live. Thank you so much for watching, and I'll see you in the next one.